2019. This is a code enforcement hearing for the City of North Miami, and I am the Special Magistrate, Jose Smith. The Special Magistrate is empowered by the Florida statutes and the code of the City of North Miami to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as observed and cited by the code officer. And if the city is not able to prove the case against you, then I will dismiss the case and you may leave. These proceedings are being recorded. Therefore, all persons that are speaking should do so one at a time to ensure that the testimony is clearly audible on the record. If folks speak over each other, the record will be unintelligible and will be of little use to the city. If English is not your primary language, then please inform me when I call your case. We have interpreters that will assist you during these proceedings. When your case is called, the property owner, the agent for the property owner, and any witnesses that you may have should come forward to the podium on your left. When asked, please speak clearly, directly into the microphone, and say your name out loud, your business, your mailing address, and your relationship to the property. If you are not the property owner or the agent of a property owner, and any witness that you may have on your behalf, you must have a power of attorney or an affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware and understand the violation that is being heard this evening, and that you do understand what is required to resolve the violation. Please answer out loud. The city will present its first case, and then the property owner and violator will be given an opportunity to testify on their own behalf, to bring forward any witnesses that you would like to testify on your behalf, and to present any evidence, including photographs, and you will have the right to cross-examine the city's witnesses. Following these proceedings, or following the presentation, following the case presentation, I will issue a finding of facts on the case. If I find that a violation of the city code exists or existed at your property, then depending upon the case, I will set an abatement date, which means a date by which you must comply with the whatever is required to correct the violation. I will impose a daily fine if I find that the city prevails, and set forth the fine amount. For new non-repeat cases, my order will also include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing date should the violation not be corrected by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table the case and will schedule another hearing in the future. If you do not agree with my findings of facts and also my ruling, then the property owner may appeal my administrative order on the case to the Circuit Court in Dade County, Miami-Dade County, Florida. An appeal must also be filed within 30 days of the date of the execution of my administrative order in order to be timely on your appeal. In accordance with the Florida statutes, if a person decides to appeal any decision made by me, the Special Magistrate, with respect to any matter considered in these proceedings, then that person will need a verbatim record or transcript of these proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the transcript, the record, shall be the sole responsibility of the appellant or the person who appeals. And it is recommended that persons who plan to appeal their case should have their own court reporter present at the proceedings. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records the order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. At this point, I'm going to turn to the police officer to administer the oath of everyone who will be testifying at tonight's hearings.
If you're going to be speaking on any case, please rise and raise your right hand to be sworn in. If you're going to be speaking on any case here tonight, raise your right hand. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do. I do. Everyone, please stand for the Pledge of Allegiance. Face the flag and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Translated. Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skills, and ability? I do. Thank you.
At this time, the code compliance manager will announce any additions, corrections, or deletions to tonight's agenda, and then we will call the first case.
Item number 22, CEGMP 2018-00072 is postponed 1 month. Item 23, CERCV 2018-00277 is complied. Item 25, CESRR 2018-00067 is complied. Item 32, CERCV 2018-00225 is complied. Item 45, CEB PR 2019-00001 is complied, and those are all the amendments and deletions to the agenda.
Very well. Anything else?
No, sir.
Madam Attorney, anything from you? Okay, let's call the first case.
The first case is item number 7, Christopher Sander. Vanessa Willis is the officer, and the case number is CESTA 2018-00010, item number 7.
City, please proceed.
Hi, good
State
evening.
your name and address for the record.
Good evening, Vanessa Willis, City of North Miami Code Compliance Officer for the City of North Miami.
Good evening, Your Honor. Mickey Marrero, law firm of Burkhardt, Riddell, Fernandez, and Larkin, 200 South Biscayne Boulevard, here on behalf of the owner.
Very well. City, you may proceed.
This particular property was cited, give me one moment. It was cited in November 27, 2018 for prohibited advertisement of short-term rentals. At that time, it was found on the Homes to Go website. So we asked that they please cease and desist advertising the home as a short-term rental. And as of today, the listing is still posted, so they are not in compliance. And I have a copy of the listing.
Would you please have it introduced into the record? I'd like to see it.
I'm sorry. I'm showing him the rear of the property on one page, and the date is highlighted down at the bottom, April 3rd, 2019. The next page, it has the address, 2076 Northeast 121st Street Road. Okay.
Mr. Marrero, is that the property in question?
It is, Your Honor.
The city is seeking adjudication of guilt and an abatement date.
Okay. Give me 1 second, please. Let me find the permit action report. Let me hear from the property owner.
Thank you, Your Honor. Your Honor, we submit to you that, yes, this was previously advertised, and in fact, there were 2 violations that were not appealed where short-term rental activity did occur in the summer, I think, and up until September of 2018. There were 2 instances. My client's the owner of the property. They have a long-term lease, and it appears that the tenant had rented it out and had put an ad up without my client's knowledge. What occurred, and I've been in touch with the code officer a couple times, and I've spoken to Mr. Cazo, the city attorney, several times on this, because I'm just trying to figure out how to get compliance, and I'll tell you why. In November, when they got that violation, the owners advised the tenant, it was removed, and what they failed to do, which they should have done, and a lot of times violators have that, code violators have that problem, they forgot to call the officer. They took it down, thought they complied, and never thought of it since. I hadn't been retained yet. I was retained because I have a prior relationship with the owner, and they just got the notice for the hearing, which was actually originally last month. I couldn't make it, so the city graciously continued it. But I got brought in because they said, look, we're getting this violation. We took it down. Turns out, and I'm not disagreeing with the officer, what happens with these short-term rental cases, I've seen it in Miami Beach, although there's a lot of folks that are guilty there. What sometimes happens, like with real estate listings, once you put it out there, all these sites start repopulating it, and it becomes a cat and mouse game, not just for code's perspective, but for the owner trying to get it off the internet. So I'm happy to come with a compliance date where I can provide proof to the city that we sent letters to these websites, wherever we find it, to remove it. There has been no short-term rental activity there in the last better part of a year. The last time was September. But unfortunately, I'm not disagreeing with her. The listings do pop up. Like when one realtor puts up a house for sale, it comes up in 30 sites. And that appears to be what happened here. I spoke to Mr. Cazo about this. He understood. So I'm just thinking how to comply. It's probably more than one site because it was there before. What I'd like to submit as a possible solution is within, let's say, 30 days, I can provide the city with evidence of letters that I can send from my office to those companies that have the listings and saying, we ask you to cease and desist the listing. And submit to you, there's no more short-term rental activity at the property. That's, I think, a solution. I'm just, but the activity has ceased, and they've taken it down, but sometimes it continues to pop up.
Well, as I understand the charge, the city is charging your client with advertising
That's correct.
in violation of city code. And I believe it's section 5-30, which prohibits advertising. There's a separate section that deals with the actual short-term rental activity.
And that's not the citation today. We
Okay.
understand, yes.
So you have a tenant, you have a lease with a tenant, and it has remedies. I'm sure that in your case, the owner
Right.
can very easily tell the tenant, if you do this again, we're going to evict you.
Correct.
So do you have a recommendation?
Special Yeah, Special Magistrate, before we move on, just to kind of rebut some of the things that he said, and you're right in reference to the code section, it is 5-30, subsection D, prohibited advertisements. It says any advertisement that promotes the occupancy or use of the residential property for the purpose of holding commercial parties, events, assemblies, gatherings, or the rental of a single-family residential property for a period of less than 3 months as prohibited by section 5-1610 of the city's land development regulations is prohibited and shall be a violation of this chapter. He stated that the last incident may have been around September, but I just wanted, for the record, to it reflect June 12, 2018, there was a civil violation ticket issued for prohibited advertising of short-term rental. They were on booking.com. That was a ticket that was issued. And then again, June 26, 2018, where the civil violation ticket was issued for, I'm sorry, that was for short-term rental. Well, give me 1 second. Short-term rental, that took place. And then you have the one from November that I wrote. You have another one that was just written March 16, 2019 for the short-term rental advertising. So this is a cat and mouse game that we have been playing. Special Magistrate, I'm not sure that the letter writing to each of these entities is going to prohibit future occurrences of short-term rental advertising. So, you know, we need some type of action. I mean, he's the attorney, so I'll let him figure that part out.
Your Honor, and just to clarify, I'm not saying, I understand the violation was in November for advertising, and that another one was issued recently for advertising. And I'm telling you that I checked, and those advertisements are there. They're just not being generated by my client or their tenant, from what we understand. So I'm trying to find a way to, you know, I can send a threatening letter to all those websites. I'm happy to do that. I've done it for clients before. But I'm saying the last time that they have a record, my client, the owner, has a record of someone actually, and I know it's not the violation before you tonight, but someone actually renting the property short-term was in September. So I submit to you graciously that it did occur. The owner knows it occurred, and they've really tried to put a stop to it.
Do you concur with the city that the advertising was for a short-term rental as opposed to a longer term?
The advertisement, I saw it, it allowed for a short-term rental. So I'm not trying to argue with the city. I understand there's an issue. I'm just trying to find the best way to solve it. And what I'm offering is at least a way that I can, as an attorney, send a letter to those companies demanding they cease and desist. And hopefully they take them down. They've attempted it before. What happens is it pops up on other sites. If you give us, I would say 30 days, I'll do the very best with my power now that I'm involved to contact those companies and make sure that happens.
Okay. So, based on the testimony that I've heard, I've considered the advertising, I've listened to the evidence, I will find that a violation exists, and I will find in favor of the city, enter an adjudication, and give you 30 days within which to comply. In the event that there is no compliance within 30 days, then I will be setting a daily fine of $150 until the violation is abated. Yes, Madam City Attorney.
Judge, we would be asking for an elevated amount. There has been, and I'm personally aware of complaints that were provided to our office regarding this going on for 2 years now, and this is coming from neighbors. So we are asking that, Your Honor, for at least $250 per day if it's not complied with.
Well, are you saying that there has actually been short-term rental activity at the premises as opposed to just merely advertising for short-term rentals?
Yes.
Because I haven't heard any evidence to that effect.
Right, and I'm not going to bring it up because it's not what's before Your Honor today, and in regards to that matter, it's irrelevant. But I do know, and I have an email regarding a neighbor specifically that's been complaining about this matter and wants answers as to this regard. I think it's a equitable solution that the attorney is going to go ahead and send these letters and get this kind of going. But if it's not complied with, I would like a higher fine, just because this has been going on for a while.
Because I have confidence in counsel and his ability to make things happen with the property owner, I I will set the fine at $250, and I will ask you to abate within 30 days. If it's not abated, then the fines will run on
Understood.
a daily basis.
And we will do everything in our power. I'll be in touch with code, and I'll provide them the letters. I'll provide them, and just to be frank, if you find sites that you let me know,
Okay.
and I'm happy to put them, because maybe I miss one, and I don't want to be in compliance for missing something, but I'm happy to work with you and get it resolved.
Okay,
Thank
thank
you.
you.
Yeah, and having dealt with this issue before, if it turns out that there's actual short-term rental activity going on, then I would like the owner to be charged under that particular section of the land development regulations, in which case my fine will be significantly higher.
Thank
Judge,
you.
is your abatement day, April 24th? I know you said 30 days, but that's a little bit less. I just wanted to have it clear for the record and for council. That's the next,
The next meeting is
that would be the next abatement date that comes up,
what date is that?
April 24th.
Is that okay
Well,
with?
I hope so, but Your Honor, I would like 30 days because I'm going to send letters. It's not like they're going to take them down that day. I'm probably going to have to send a second letter. I think 30 days gives me enough time to do it. I don't need more.
Yeah.
But I don't want to have less because it's not completely under my control.
All right, I'll give you 30 days. So let's schedule it for whatever hearing follows that 30-day period.
That's May 29th.
Yes. That'll be the date.
So but the abatement date, now
It's 30
it
days.
should be, right, 30 days,
Right.
but we'll be back on calendar on the date specified, correct?
If there's
Yes,
no
correct.
compliance.
Right, yeah.
Right. Okay.
Correct.
Understood.
Anything
Okay,
else?
thank you. Thank you.
Thank you.
Thank you, Your Honor. Have a good evening.
The next item on the agenda is item number 21, Grupo Tfj Properties. Shanna Sanders is the officer. The case number is CELDR 2016-00001, item 21.
Please state your full name and address for the record.
Kevin Burns, 2065 Allen Manor Drive, representing the owners. And I am registered with the city.
And the owner is Grupo Tfj Properties LLC.
Correct.
City, please proceed.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for reports of previous compliance. This is a case for violation of land development regulations for having more vehicles parked at the property than what the city allows through the agreement that they made with the city. Long story short, this is the Fiat dealership on Biscayne Boulevard and 131st. They have a contract with the city which states that they can have 26 vehicles parked at the property, 6 of which can be used. At any given time, they've had 40, 50 vehicles, sometimes 10, 20, that are used. As of Wednesday, the 27th, when I did the reinspection, there were 62 vehicles at the property, for which 21 of them were used.
How many?
There were 62 vehicles in total, 21 which were used. And again, our agreement with them states that they can only have 26, 6 which are to be used vehicles.
Counsel?
Good evening, sir. This case goes back approximately almost 2 years. We've been working diligently with the city, and I'm sure the assistant city attorney will concur that we have been diligently working with the city, and that the request tonight is actually to negate the order that you put in last month. The city attorney and myself, neither one of us were here to ask for a postponement of that item and to abate any sense of a fine. What has happened, making a long story short, is the city was going through land development regulations rewrite, and the rewrite was part of the package. The planning commission made all the changes that were recommended. When it got to the city council, out of 100 recommendations, they only were able to deal with about 20, and this one got skipped over. We have been working with the city attorney's office and the community planning department months on end and are ready to address the planning commission at any time. However, issues that involving the city keep popping up and keep pushing us further away from getting back in front of the city commission and the planning commission. Tentatively, the city attorney's office has come up with some language that they feel is appropriate, and we're going to hopefully be on the May planning commission. However, due to city elections coming up and then summer break for the council, the city attorney and I don't believe it's going to get before the city council until September due to the fact they have council break, and then the first meetings back they start with the budget hearings, and this item isn't the biggest pressing thing for them. However, we have been trying to work diligently with the city attorney very successfully, and again, I'll let the assistant city attorney make any comment that we have. Again, we've been working diligently with them and cooperating, and it does not just affect our property, it affects that whole particular district, Your Honor.
Are you seeking to have a land use, and I'll ask you to comment, but are you seeking to amend the development order to allow you to have more vehicles, less vehicles?
Yes, and it's district-wide for that particular district. It's a unique situation because there's very few locations within the city, within that zoning, that even allows vehicles. When we did the comprehensive plan, this item was brought up. The Planning Commission approved it and moved it forward. However, as I said, the City Council wasn't able to address all the items that were recommended, and we were left in limbo again. We brought it back forward again to correct it because the city realizes that they don't want to lose this dealership, and that having 20 cars out in front of a dealership doesn't make any sense. And that's why they've been working with us graciously, and also has been able to postpone this item. And again, we would have been in front of you last month to postpone it again with the blessings of the city attorney's office because legislation is in process. We just can't hurry that process up, and the city attorney can't, hurry it up either, sir.
I want to hear from the city attorney.
Judge, for the most part, everything is correct. It is on the May agenda, but we have no problem, as Mr. Burns has been working with Mr. Cazot regarding this matter, with tabling it until September would
That's
you
what
say
he's
is an
saying,
appropriate
September.
date for us to come up with something regarding this and for it to have a reading and for them to go through it. In terms of the last magistrate's decision and ruling that she made, that was before Judge Beatrice Cazot. The next time that she's on is May 1st, and I would suggest putting it before her in order to change that order. It's in your Honor's discretion, but that's the next time that she's on at 6 p.m. And if she wants to change that.
I would do that. I would have a special magistrate, because I'll continue to oversee the case.
Okay.
Since it's been around since January of 2016, and there's an abatement order with fines accruing of $500 per day. And I would urge you to continue working with the city attorney's office, perhaps in an effort to minimize the number of non-compliant automobiles, if you will. So, if you're allowed 26 and you have 62, that's a problem. And it may very well be that you'll be allowed to have 62 vehicles, but it seems like it's a very substantial deviation from the original development order. So,
if I may make a comment, the original site has plenty of parking for excess of about 70 vehicles. When that initial number was presented, it was us that created that number. The city didn't have a number set. We actually, as a concept that the Fiat Chrysler dealerships had, that it was a boutique thing, that plan didn't work out. We're the ones who set that that number, and that's what the number that the city used to make up their land development regulation at the time, because at the time there was none. And so we kind of like made our own mistakes addressing that number. There is no, the city attorney's office has allowed us to continue on operating the way that it is, because through to keep the dealership from leaving and just shutting down and causing the economic hardship to the dealership, but also to the residents and to the employees and so forth, the city attorney's office and the has been very gracious to allow it to operate and postpone the item and not asking us to modify anything at this time. And we will be glad to come back before the other special magistrate.
Right,
and
so
speak to her about it.
I will table it for the May 1st special magistrate hearing for her to decide what to do at that time.
Okay, very good.
Thank you.
Thank you.
Thank you.
Next case.
The next item is item 38, Peter Absada. Karen Jean Lewis is the officer. The case number is CERCV 2018-00262. Item 38.
Spanish interpreter?
Sir, do you need an interpreter?
Yeah.
Okay.
Yo quiero preguntarle.
City, you may proceed.
Good evening, Co-Compliance Officer Karen Jean Lewis. The property of 940 Northwest 134 was cited back on December 7, 2018 to either remove, relocate, or obtain an administrative variance for the boat being stored on the property. As of the last reinspection date of March 27, the boat has not been removed, and there's no variance on file.
Any pictures you want to offer into evidence?
Yes, just a moment. In the pictures, you'll see the boat that's on the property and then also the notice to appear that was posted for the hearing.
Sir, would you please state your full name and street address for the record?
Diga su nombre completo.
William Izquierdo.
William Michel. Su dirección,
940
940.
No West.
Spell your last name, please.
Apellido, otra vez.
Izquierdo.
Izquierdo.
Spell it.
940
940
Northwest
Northwest
134 Street.
134th Street.
Spell your last name, sir.
Deletreo el apellido en español.
I Z Q U I R D O.
I know how to spell it. I just wanted to be clear for the record.
ID I Z Q U I R D O.
Are you the owner?
¿Es el dueño usted?
No, estoy rentado.
No, I'm renting.
De bote sí.
I'm the owner of the boat.
And you're renting from the property owner?
¿Está rentando usted el dueño de la propiedad?
Sí.
Yes.
Do you contest the violation?
¿Está en desacuerdo con esta violación?
No, porque no sabía.
No, I just didn't know.
Will you agree to remove it?
¿Está de acuerdo en quitarlo?
No. Aquí me mandaron un papel que dice que no lo puedo tener al lado ni al frente.
I have a paper in which says that I cannot have it in the front or in one side.
Madam City Attorney, could you explain what the code section calls for?
Explicar la
Well,
abogada
Judge, first we
cuál es
can't,
el código.
does he have power of attorney to be speaking on behalf of this,
Okay.
of the property owner?
If
He's the
he's, if he's the tenant and he owns the boat,
Él es el dueño del
I,
bote, dice.
I believe that he would have standing, and I would let him testify.
Okay.
Could you explain the provisions of the code section allegedly violated?
Puede explicarle, le está diciendo de que explique qué código está violando al parquear el bote ahí. Espera un segundo.
So it's on his notice of violation.
Bueno, estoy viendo la
It's
notificación de
prohibited to
violación.
park or store recreational vehicles, boats,
Que no
trailers,
se permite
campers
que se
in the
parquee
front or side
vehículos
yard
en el
abutting
frente
street
y
without
en el
first
costado.
receiving administrative variance approval.
menos que uno
Please remove,
consiga un
relocate, or
permiso.
obtain an
Tiene que
administrative
quitar
variance for
o
the boat
remover o
being
reubicar.
stored at the residence by
Y
the
no puede estar
reinspection date. If
en
additional
eso.
item is
Y
needed,
tiene
please
que estar
contact the code
quitado para
officer.
la fecha que se hace la reinspección.
That's chapter 29, section
Es el
5,
capítulo
1405.
39 y esa ley en el capítulo.
Recreational vehicle parking requires
Se
permit.
refiere a vehículos recreacionales.
So the city takes the position legally that the vehicle is not allowed
El
on your
vehículo
property
no se le
at
permite
all.
en su propiedad para nada.
Ni en la parte de atrás, porque él no está acostado.
Not even in the back. Because
Nowhere.
En ningún lugar de eso, pues.
So you need to move it.
Entonces,
Otherwise,
necesita
you're going to be
quitar
fined
de otra forma.
on a daily basis.
Le van a dar
Is this is not a
multa
repeat violation, is
diaria.
it?
No.
Okay. Who is the owner of the property?
¿Quién es el dueño de la propiedad?
Peter.
Peter.
Peter what?
¿Peter qué? Abesala. A-B-S-A-D-A.
And is he aware that you're storing a boat at the residence?
¿Él sabe que está usted parqueando el bote en la residencia? ¿Él lo sabe?
Sí, él sabe.
He knows, yes.
You have a lease with Peter?
¿Usted tiene un contrato de alquiler con Peter?
Sí.
Yes.
Okay. Um,
Judge, he can either get a variance or remove it.
Son dos cosas. Uno, que consigue un
Th-
permiso
this-
o tiene que
The,
quitarlo.
the city has a process by which you can apply for a variance.
La ciudad tiene un proceso mediante la cual usted puede pedir un permiso.
Ya lo tengo todo.
I have everything here.
What is everything?
¿Qué es todo?
Ya me dio un poder para hacer el permiso. Ya tengo
I have a power in order to obtain the permit.
tengo todo lo que me dijo la ciudad. Nada más tengo que ir a entregarlo ahí para él. Ya tengo
I
todo.
have all the papers required by
Madam
the
City
city.
Attorney, would you
I
like
have just
to see
need
what
to
he
submit it.
has and advise me accordingly?
Does he have an application? So he does have a power of attorney. He does have a power of attorney in order to obtain the variance.
Está viendo que usted tiene un poder
And
para obtener,
the application.
para obtener
And
ese
it looks like
permiso.
he's applied,
Y pienso, ella dice que ya ha
so he's in the
aplicado.
process, Judge.
What is your recommendation then?
¿Y qué recomienda usted? Le está diciendo.
30 or 60? Yeah, Judge, I would say to table it, to reset it. I'm gonna advise of 60 days, just because it
Que
might
esto
take a little
se
bit longer on our end
reprograme.
regarding the process.
Y tal vez puede
Okay,
tomar un tiempo más largo para
based
obtener
on
But he has
the,
applied, so-
based on the evidence presented and the recommendation
y la
of the
recomendación
city, I
de la
am
ciudad,
going to
voy a
table this matter until it is
posponer esto
rescheduled again by the
y
city.
La ciudad va a poner otra vez en el horario esta cita acá.
Pero con esto puedo ya sacar mi permiso todo normal.
So with this, can I obtain a permit with this?
That's up to the administrative staff, and if it complies with the code, you should be okay.
Okay.
What's the reset date that Your Honor would like?
Ahí tiene que llevarlo.
May 29th.
Okay.
Esas tres
Thank you.
cosas tiene que llevar ahí. Y
He's
dice que,
paying
y dice
$293.
If we're tabling it, it should be
tomorrow.
June the
que la,
5th.
que la ciudad le va a
June the
dar
5th would be the hearing,
If
but
we're
I,
tabling it.
right, if he hasn't obtained the variance, then I would like him to come back on June 5 and explain why he hasn't been able to obtain it.
que la solicitud ellas lo llevan a una mesa, a una junta y ellos son los que deciden si le dan el permiso o no. Eso.
Do you understand, sir?
Entiendo. Yes.
Okay, good luck. Have a good evening.
Buena suerte.
The next item on the agenda is item number 10, Collins Castillo. Jose Perez is the officer, and the case number CESOD 2019-00001, item number 10.
One second, please. Sir, would you please state your full name and street address for the record?
Collins Castillo, 12655 Northwest 2nd Ave, North Miami, Florida, 33168.
Are you the owner of the property?
Yes, sir.
Do you know what the city is alleging happened at your property?
Yes, they say should be no parking on the lawn in front of the house, and the car have been removed.
That's not what I'm showing, so I'm going to ask the city to present its case.
City of North Miami Code Enforcement Officer Perez. Today we're hearing the case in reference to the property at 12655 Northwest 2nd Avenue. The resident is referring to a prior violation that was accompanied to this, but was cured when he seized parking in the front lawn. This is a separate violation for the sodding that needs to be replaced in front of the property. I have photographs to enter into evidence after I show them to the resident.
So originally there were 2 violations, now there's 1.
Correct, one was abated.
Okay. And this one is for the swale area?
Correct, the sod in the swell area.
Sir, do you understand
I understand,
what you're
but
being cited for?
I understand, but I didn't get this one.
They were issued the same day, and they were accompanied together. They were posted on the same day, and they were mailed out on the same day as well.
And what date was that?
January 4th, 2019.
Okay, so the old violation was for parking vehicles in the front of the house, and this one is for the swale.
Correct.
Sir, do you dispute
No, not at all.
the swale violation? Do you
No,
understand?
I understand, but I didn't receive that.
Okay. How much time do you need to correct that violation?
I really can't tell you. So
30 days?
30?
30 days?
well, you could give me. I just have to work and make the money. That's it. I don't have money on this side to do it. As soon as possible. If you could give me 30 days, I work out with that. If I can, I come back.
Okay. Is that okay with the city?
The city has no objections to the 30 days. If the resident needs an extension prior to those 30 days expanding, the resident can contact me and we get scheduled for an extension.
Okay, so you heard that the city is willing to work with you to help you with the swale issue.
That's fine with me.
Okay, so based on the testimony that I've heard, the photograph, finding that there is service of process, I find that the violation exists, that, and so I find for the city, I enter an adjudication and set a compliance date of, an abatement date of 30 days. So that would be, let's do May 29th. And if there's no compliance after the compliance date, I will set a fine of $250 until the violation is abated or complied with.
Thank you.
Thank you.
The next
Thanks,
item, the next item is item 11, Carinthia Ford. Jose Perez is the officer. The case number is CEOSV 2018-00112, item 11.
Who's going to be speaking?
Both of us.
Both of you? Would you both state your full name and street address for the record?
My name is Robert Ford. The address is 8937 Southwest 19th Street, Miramar, Florida 33025.
And your name, ma'am?
Carinthia Mary Ford, 8937 Southwest 19th Street, Miramar, Florida 33025.
Is this your residence, or is this
No, no, no,
you're
rented.
renting it to someone?
Yes.
Yeah, we rented it out.
Okay. And are the vehicles that are parked there your vehicles or the tenants' vehicles?
Tenants.
Okay. City, proceed. This
City-
is a repeat violation, right?
Yes.
Okay.
City of North Miami Code Enforcement Officer Perez. Today we're hearing the case in reference to the property at 525 Northwest 134th Street. May we hear both of them at the same time?
Let's hear the first one, which is what number?
Item
No,
number
no.
11, CEOSB 2018-00112.
Okay, so let's hear 11 first, which is the paint issue, correct?
No.
No?
This is the oversized vehicle.
I'm sorry.
Vehicles being stored in the rear of the property, specifically semi-trucks and transport trucks.
Got it. Let's hear that one.
Okay. As stated previously, it is a repeat violation. I've spoken to the tenant and I've given several warnings, as well as previously several other officers have given warnings and open violations for the storage of the commercial trucks in the rear of the property, that being a Freightliner truck, as well as a two Freightliner trucks actually, one being for cargo and the other one being for car transports. I have several photographs that I am going to admit into evidence.
Show them to the property owner.
We were not even aware of those things.
Is that your property, ma'am?
Yes, it's my property.
This was taken actually on the 28th.
Okay.
It's ongoing. City will register to the property itself.
You see that little gang? Look the number on the car on that?
Because he has our address on it, but we have nothing to do with that. Whatever he is, doing with that truck, because
Well, before you testify, I want to let the
okay.
city proceed with admitting the photographs into evidence.
And I'd like to take judicial
Judicial
notice that on the photographs you can see that the truck is registered, as in the business is registered to that address itself, which brings up a whole nother violation, being them running the business from the property itself.
And this is a single-family residential neighborhood?
Correct.
And running a business out of a single-family residential neighborhood is not permitted by the code, correct?
Correct.
I will admit the 5-6 photographs into evidence as the city's composite exhibit number 1. I'm sorry, there's 7. And you may proceed.
So as previously stated, this is a repeat violation. Those photographs were dating as far back as December 2018 and as late as March 28th, being last week Thursday, that has been occurring. So at this point, the city is obviously wishing to pursue this as a repeat offender.
What is the, 1 second, you can't speak right now, ma'am. What is the fine schedule for a repeat offender on this type of violation?
Let me confer with counsel, 1 sec.
Okay. I think I know what it is, but I want to hear it from you.
Okay. No, we're
Okay,
My apologies.
no problem.
Yeah, the city wants to go with the minimum fine amount for the repeat offender, which, if I'm not mistaken, is the $1,000 per day, if not abated.
And that's per section 21-20 of the code?
Yes.
Now I want to hear from the property owner.
Yes, Your Honor. We rented this property out to Mr. Moses Dale, you know what I mean, a single family home. And I know he was in the wrecking business, you know what I mean, picking up cars. But I didn't know he was running a business out of the home. So when I go over there, none of these vehicles be in front of the yard and behind in the back of the yard.
Well, you're not being charged today with running a business. You're
well,
being charged with having oversized vehicles stored in the rear of your property.
But
That's the violation.
But we wasn't aware of him having trucks or vehicles in the back of the yard.
Can I say
Yes,
one more
ma'am.
thing? Another
Speak
thing is
into the
that-
mic, please.
Oh, sorry. Another thing is that I got that on the 30th. If they had gone there and gave him certain citations, why wasn't addressed to my address in Miramar instead of North Miami, or send us something to say that this was happening? We never know that he had those vehicles parked there, or the city had come and speak to him. It's only on Thursday or what day we got that saying that, the violations. We were not aware of anything was written to us. Being as the property owner, that it should have been sent to our address instead of going to,
The answer is that the code provides for service by delivering the violation, the notice of violation, to the property. And so if you have a tenant, then the tenant should have advised you about the violation. But you did get notice for today's hearing, correct?
to my other address, not to for the North Miami area. It came to my other home address, being the property owner to that. to
Right.
North Miami.
Okay, so I'll ask the city, how did the city learn that the property owner resided elsewhere?
So on the tax rolls, the property address stated for the property owner is 8937 Southwest 19th Street in Miramar 33025. The notices of violation have been mailed out to there, as well as the notices to appear, which may have gotten lost in the mail. I'm not going to go into speculation with that, but the notices were also posted on the property itself. So the responsibility of the tenant to present these to the property owner is in question here.
So you complied with the code by posting?
By posting and mailing out.
And mailing, and
Correct.
that's what the record reflects, that
Yes.
there's proper service,
Yes.
correct? How much time, Mr. and Mrs. Ford, how much time do you need to get your tenant to remove the offending vehicles?
Well, Your Honor, we're gonna take the customary 30 days. We're gonna try to have it done as soon as possible, though. Thank you.
City, do you want me to adjudicate and levy a fine? Or do you want me to provide an abatement date by which they must comply first?
Council's advising that it is a repeat offender, so we would like to levy the fine.
All right, so based on the testimony of the city's code compliance officer, the photographs and the evidence presented, considering that it is a repeat violation, proper notice having been given, I find in favor of the city, and I enter an adjudication and set a fine of $1,000. If there's no compliance, if the violation remains unabated, then I will run those fines at $1,000 a day, beginning 30 days.
April 24th.
Yes. We'll do April. We'll do April 24th. By that time, you need to have those vehicles removed. If not, the fines will accrue, and then I will ratify the fine, or the next special magistrate will ratify the fine at the next ensuing special magistrate hearing, which is on May 1st.
Okay, we still need to hear the one for the recreational vehicle being CERCV 2018-00268.
That's a separate vehicle.
That's the one for a boat being stored in the rear of the property next to the semi-trucks.
So there were two vehicles.
There's 2 Freightliners and a
Okay.
boat.
And a boat.
And a boat.
And now you're telling me about a boat.
Correct. The second
Okay.
case is in reference to the boat.
Okay, so why don't you present your case? Let me see the photographs, or are they the same photographs that you showed me before?
Separate photographs.
Okay.
You want me to run my case again, or could I just present?
Just to the extent that it deals with that particular violation, which for the record ends in 00268, and it involves a boat at 525 Northwest 134th Street.
Okay. City of North Miami Code Enforcement Officer Perez. We're hearing the case in reference to the property located at 525 Northwest 134th Street. This is in reference to a recreational vehicle being stored in the rear of the property. To be specific, a white Robalo boat. The violation was opened on January 4th, 2019. Proper service was done, and I have the following photographs to present to the residents, and then it's evidence.
Mr. and Mrs. Ford, is that a photograph of a boat stored on your property at 525 Northwest 134th Street?
We have never seen that. We don't know if it is done when we're not, because we don't come to the property very often, but we were not aware of the boat or the vehicle being stored in the back of the yard.
I understand, but is it your property?
Yes, it
Okay.
is our property.
Okay. Now, this is not a repeat violation, is it?
For the boat, 1 second. No, it would not be a repeat violation for that one.
Okay. So, what I'm going to do on this case is I'm going to give them the same 30 days as in the prior case. I'm not going to assess a fine at this point. However, if there is no compliance by the compliance date of April 24th, is that what I said before?
Yes.
If there's no compliance by April 24th and the boat is not removed, then I'm going to assess a daily fine of $250. Thank you.
Thank you.
Can I ask one question, just
Sure.
to be clear?
Sure.
That $1,000, we got to pay that by April 24th or until, or what? I don't understand that $1,000.
Well, that's going to be up to the city to determine how and when the fine is paid. But I would encourage you to remove it or have your tenant remove everything, and then come back when the date of the hearing and tell us what happened, and then we'll see what happens with the fine.
So we'll be getting a notice to come back, right?
Yes.
Okay, all right.
But I did find in favor of the city. I adjudicated the first case in favor of the city, and I assessed a fine of $1,000 because it is a repeat offender.
Okay.
It could have been 5,000, and I set the fine at 1,000 based on the recommendation of the city.
But I would like in future, all correspondence, anything be sent to my address at 8937.
It does.
Okay, because we didn't get the others. But
It does.
we agree.
You need to have a serious conversation with your tenant, and if your tenant does not comply, then I would suggest that you take legal action against the tenant.
Okay, thanks a lot.
Thank you.
The next case is item 48, Timothy Randolph. Jose Perez is the officer. The case number is CEG MP 2018-00449, item 48.
Sir, would you please state your full name and street address for the record?
Timothy Randolph, 505 Opelika Boulevard.
Is that your residence?
Yes.
You own it?
Yes.
Do you understand the nature of the violation?
I would like to know the violation.
So then let's have the city present its case.
City of North Miami Code Enforcement Officer Perez. Today we're hearing the case in reference to the property at 505 Opelika Boulevard. This is in reference to general maintenance of the property. To be specific, the property exterior should be painted and in good repair. This also includes the awnings on the south side of the property. I have photographs to show the resident.
Please. Is that your property, sir, depicted on those photographs?
Yes.
Do you understand the nature of the violation now?
Yes, he just want me to paint some trim on the house.
How much time do you need?
I take the 30 days.
Let me first introduce the 3 photographs depicting the house and the violations. Is 30 days okay with the city?
No objections.
Okay, so based on the testimony of the city's code compliance officer, the photographs presented depicting that the cited condition still exists and that proper notice has been given, I find in favor of the city. Enter an adjudication and set an abatement date of 30 days, which would take it to April 24th?
24th.
April 24th is the compliance date, and in the event that there is no non-compliance, there will be a daily fine of $250 until the violation is abated. Thank you very much.
Thank you.
Yes, sir.
Can I just paint that and take some pictures of it and come present it before that date?
The
if
officer would have to go out and take a look.
Yeah.
Oh, okay.
So you would schedule with me, I would go by, and I would close it out as soon as it's painted.
Okay.
I could give you my business card now.
All right.
So you don't have to come back. If the code officer is satisfied with the paint job, he will dismiss the case.